in the writ petition, the stand taken by the state and the NIDC is that the basic order has not been challenged.
Okay.
Only the order which there's a decision of the board of directors, that is what they say. And then on the basis of that decision of the board of directors, an order was issued. I have already challenged the order, but the stand taken is that the basic order has not been challenged.
Okay.
So by way of abundant caution, Your Lordship, I wish to amend the writ petition and challenge even the basic order.
Okay. So today,
So unlisted application for that, Your Lordship, to amend the petition.
amend the petition.
Yes, madam. After the motion, Your Lordship, listed motion, after admission?
Or can it be listed tomorrow along with this?
Yes.
Will it be listed tomorrow along with this? The same.
Tomorrow, I'm not here tomorrow, madam. Or on Tuesday. On
Okay.
Tuesday then.
Okay.
On Tuesday.
That will do. Okay.
Tuesday.
Okay. Tuesday.
Then along with the,
24.
yes, along with 24.
Okay.
And in 24, there is an interim order, Your Lordship, to continue until the next year.
It will continue. Okay. Okay. It's grateful by the, it's grateful by Mr. Azimomi, Lana Council for the petitioner. List this matter on Tuesday. The interim order shall continue till then.
And along with the IA also.
Hello, I already.
I've
numbered.
already filed, Your Lordship,
Okay. That will
along with the connected
automatically-
IA,
Oh.
along with the connected IA.
Along with the connected ID. Okay.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 16. Lordship, here by the order dated 24 June, I have been directed to produce all the documents.
Directed to?
To produce the recommendation submitted by the Pay Anomaly Committee.
Okay.
So I'm yet to receive an instruction. So this matter may be released after 3 weeks.
Who is for the petitioner? Yeah?
Your Lordship, I'm for the petitioners.
Okay.
I'm for the respondent.
So you are yet to obtain instruction.
Yes.
Your Lordship, 4 weeks was granted to the state respondents, and this is an old matter. So if the state may be directed to at least expedite the matter at the earliest, because the matter has been dragging on for years together.
Can you just ask item 16 here? By last order, it was directed.
Yes, yes.
What was the
No,
direction?
I have conducted, but I have not yet reached.
Your Lordship, the state is to file an additional affidavit
Okay.
in respect to whether the pay anomaly committee where the petitioner submitted a representation has been acted upon, and if it has been acted upon, on what basis? That report is to be filed before His Honorable Court by way of filing an additional
Additional
affidavit.
affidavit.
Okay. Mr.
In teams of,
Additional AG
yes.
for the state of Nagaland. Some state. He is yet to receive an instruction with regards to filing of the additional, with regards to filing of the additional affidavit as directed by this court on 24/6/2024 and placed for how much time?
3 weeks time.
3 weeks, for the 3 weeks times. So 3 weeks times can be granted.
My lord, but let them also expedite the matter so that this matter will not drag on further again.
Okay. The prayer is allowed, huh? Okay. Mr. Seki, Learned Counsel for the petitioner is also present. Since the matter is a long pending case, the state shall ensure that the additional affidavit is directed by this court on 24/6/2024 is filed by the next date. Huh? Okay.
Blush, Your Lordship.
May I please, Your Lordship? With the consent of the parties, I beg to mention item number 10, Lordship.
Item,
Item 10, Lordship.
okay,
Lordship, service upon respondent number 2 is completed, and in fact, they have filed their affidavit today. Lordship. We are yet to receive a copy also. So, Lordship, may kindly fix this matter in the month of August. So that we will file our affidavit in reply, Lordship, the affidavit of petition.
You have respondent number 3.
Yes, your lordship.
You have not yet received copy.
I have not received.
You served copy?
Yes, your lordship.
Lordship, I
You
can
are-
fix it on 30th of August. Lordship.
30th.
Yes, Lordship.
So will not fix the date.
Lordship, there will be difficulty on our part if the matter is not fixed, since we are
Okay.
obsession council, Lordship.
Miss, your miss,
Alitosi.
land counsel for the respondent number 3.
Number two.
Two.
Number 2. 2 has filed or 3?
Two has
two,
filed.
Lordship.
Okay, fine.
14/16/4.
Affidavit in opposition, however, sorry. The copy has not have been served to the land counsel for the petitioner. The land counsel for the respondent shall furnish a copy of the affidavit filed by the respondent number on behalf of the respondent number 2 only, to the land counsel for the petitioner. Stop. Is paid for by the land counsel for the petitioner. This is matter after, on
30th of
38th.
August.
38th, okay. It is prayed for by the land counsel for the parties. This is matter on 30th August
For admission hearing.
for admission here. Okay,
Much obliged.
Mr. Lordship, Lordship, I'd like to mention item number 5.
Okay.
Yes, I've taken the concern of the opposite party, your Lordship. Can you grant list this matter after 4 weeks to obtain instruction, the status of the case, your Lordship?
okay. Miss V. Sukri, land additional AG with the consent of the land counsel for the petitioner, prays for listing this matter after 4 weeks along with the updated.
To obtain the status of the case. I've already
Oh.
filed my affidavit. Your
Okay,
Lordship.
okay.
Yes,
Along with the instruction on the status of the
case,
case.
much obliged.
Your
The prayer is
Lordship,
allowed. This
we
is,
will be
uh,
finding implement.
The prayer is allowed, this is matter after 4 weeks. Yes.
Your Lordship, here I'm appearing for the petitioner and we will be filing in IA for implement
Where?
in item 5.
Oh, item 5,
Yes,
you
your
will be
Lordship.
filing?
IA for implement.
Okay. Miss,
Alitosi.
implement of the new party or
New incumbent.
new incumbent? Oh, Miss. You are Miss,
Alitosi.
press for allowing her to file IA for implement of the new incumbent. Okay, the prayer is allowed. Okay, list is matter after 4 weeks. No?
Much
Okay.
obliged.
May it please your lordship.
Yes,
Item number 6, that is a contempt matter. Now, in this matter, my instructions today is that the deputy commissioner who was not otherwise complying with the payment of the compensation
Mhm.
is presently now doing his work, and the payments are now been released, but not 100%. But the ground was because of the ULP elections and the MP elections. Therefore, his entire staff was busy in those things. But now he is going ahead. My prayer before lordship is that if the matter can be taken up after a month, by that time, I think the deputy commissioner will be furnishing the compliance report and the matter can thereafter be, I think, closed. I have
Okay.
informed the other side also. We
Okay.
have no objections to that.
Mr. Ansuman Sharma. With the consent of the other side, praise for listing this matter after a week.
On 30th of August, one matter was fixed. That matter also I'm appearing on item number 10. So,
38th,
30th of August, lordship.
okay. To which Mr. Jimomi Land Council for the respondent has no objection. The prayer is allowed. List this matter on 30th August.
Obliged, your lordship.
Lordship, I beg to
30.
mention hearing item number 19 and 20, Lordship. Lordship, since I have some personal difficulty today, Lordship, if Lordship can please to run this matter after,
You have 19 and 20,
Lordship,
it's a criminal petition.
Lordship. Here I'm for the state respondent.
It was for the
My lord, I'm appearing for the private respondent.
private respondent.
Yes.
I am for the petitioner, Lordship.
Okay. Private respondent is, I think here, some agreement entered between the parties or what? No,
No.
okay, not here in this case. 19 and 20,
Lordship,
when do you want, you said?
a week's time.
Week's time. He's praying for 1 week.
I have some personal difficulty.
Hmm?
I have some personal difficulty today.
Then counsel for the respondent has some personal difficulties and prays for listing this matter after a week. Hello.
Fix it.
Okay. What is it? You have any objection?
Where is the long pending case that is,
Okay,
I am petitioner.
okay, you are Mr.
H. Raman, senior advocate.
Okay. H. Raman, Lana Senior Counsel, assisted by,
Assisted by
Vijayadas.
Vijitas, I Jamil.
okay, Lucidas I. Jamil. I. Jamil, Lana Counsel for the petitioner is present, stop. Mr. Jimomi. Lana Counsel for the respondent number, sorry, stay respondent, okay. And you are for
private respondent, madam.
respondent number,
Respondent one.
okay.
Respondent one.
Mr. Wickham, Lana Counsel for the respondent number 1 is present. Mr. Jimomi, Lana Counsel for the respondent number 2 prays for
A week's time.
a week's time. Okay, to which the Lana Counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after a week. Okay,
Let it be fixed date, Lord. I forgot.
yes,
Or should I fix date? A date maybe.
fix date.
Yes,
When-
Lord.
When do you want? When?
1st of August.
1st of August.
Uh,
Is it okay?
Okay.
Okay.
Let it be 3rd, 4th August. 3rd or 4th August.
Fifth of the Monday.
5th,
No,
Fifth?
5th no, 5th is my personal difficulty. Let it be on 4th or 3rd.
okay. 3rd or 4th, any day?
Third and Sunday, third and fourth.
Okay, age prayed for by,
Third and fourth is Saturday, third is Saturday and fourth is Sunday.
okay, 3rd is Saturday and 4th is Sunday,
Then let it be on 9th,
9th.
8th, 9th.
Age prayed for by
Ninth.
Lana Council for the party, list this matter on 8th,
Ninth.
9th, okay, 9th.
9th. Lord.
May I please? Roshi, I beg to mention item number 18.
Okay,
Today, my senior has some personal difficulties, so I pray the matter may come on 1st of August, Roshi,
you are for?
for a revisionist petition.
Okay, Mr.
Item.
Zamir. Submits that he is senior. Mr.
TP Jamil.
T.B. Zamir has some personal difficulties and prays for listing this matter after. Prays
Week.
for the adjournment and to be listed on
A week, Lord.
after a week, okay. The prayers of made has not been objected to by the Lana Council for the respondent. Accordingly, the prayer is allowed. List this matter after a week. Okay,
Obliged, Lord.
May it please, my lord.
yes,
Lordship, I beg to mention item number 8. This one, affidavit is ready and if not today, I'll be filing by tomorrow. Affidavit in reply to the affidavit in opposition of the respondent government. So Lordship, with the consent of the learned government advocate, let the matter be, it's a covered case, Lordship. So let the matter be fixed for admission hearing on 1st August, Lordship, that is Thursday.
okay. Ms. Judge Gomi, Lana Council for the petitioner, submits that he is filing affidavit in reply today itself and prays for listing this matter on 1st August.
Today,
Which-
if not today, tomorrow, I'm waiting for the signature, Lordship,
Okay,
by
Okay.
tomorrow.
he is filing affidavit in reply, within 2 days. Staff and prays for listing this matter on 1st August, to which Mr. Jimomi Lana Council for the respondent has no objection. Is prayed, list this matter on 1st August, okay,
For admission hearing, Lordship,
for admission hearing.
which is a fixed item.
Mm.
Obliged.
Yeah, please, Your Lordship. Your Lordship, I beg to mention hearing item number 17. Kindly allow the matter to be listed after 3 weeks. As my senior is on this.
Okay, is prayed for, on a joint prayer made by the Lana Council for the party, list this matter after
3 weeks.
3 weeks. Okay,
Much pleasure.
May I please, Your Lordship?
yes,
I beg to mention item number 21.
on behalf of V Devnath. He is out of station, so can you list the matter after 3 weeks?
No objection. Okay, Miss,
The April,
submitted. Mr. Sri V, the Lana Council for the applicant, Mr. V Devnath is out of the station, hence pray for adjournment and to be listed on
after
After?
3 weeks.
after 3 weeks. To which Miss
I have mentioned.
Lana Council for the respondent has no objection. The prayer is allowed. List is matter after 3 weeks.
Lordship, I have similar prayer for item number 14.
Yes,
Yes, Lordship, I'm appearing on behalf of BN Sharma for respondent number 1.
okay, who is for the petition?
I'm praying for the appellant, Lordship.
Okay. No objection.
No objection.
Okay, Miss,
The April,
okay. Appearing on behalf of B and Sharma, Lana Council for the respondent number 1, prays for
after 3 weeks, Your Lordship.
listing this matter after 3 weeks, to which Mr. Lana Council for the appellant has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
May it please, Your Lordship.
Yes.
I beg to mention hearing item number 23. My senior has personal difficulties, so kindly let the matter come up on 1st of August.
Item 23.
Yes, Your Lordship.
These matter then this okay. You want these to be listed on
1st of August.
1st August. Okay, Miss
My motion now.
Lana Council for the petitioner prays for listing this matter on 1st of August. The prayer not objected to by the Lana Council for the respondent. Accordingly, the prayer is allowed. List this matter on 1st August. Okay.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 15, 15.
Yes.
Lordship, may be listed after 2 weeks. I have some difficulty to the lordship.
No objections, Lordship.
Okay. Mr. Angami, Lana Council for the respondent. Prays for listing this matter after
2 weeks. Lordship.
2 weeks, as he has some personal difficulties today. Mr. Santiago, Lana Council for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
Yes.
For motion, item number 2.
Lordship, here the respondent contenders, they are in deliberate contempt of this honorable court's order. First in WPC 128.
Now, how the contempt is constituted here?
Lordship, the petitioner here,
Yes.
who was the petitioner in the writ petition, he was excommunicated, Lordship,
Hmm.
by his village.
But there was no direction to issue some order or do something.
Now, Lordship,
Hmm.
if my Lord may kindly go to the decision passed by this honorable court.
It is not the case probably that the court has directed something and respond and.
Yes, Lordship,
party
now,
has not
Lordship.
done that.
Lordship,
Hmm.
what cannot be done directly,
Hmm.
can it also be done indirectly?
That is true, that is true.
Yes,
But
Lordship,
then,
now, Lordship, the excommunication has been set aside.
yes,
Now, once that
are
is
they
set
doing
aside,
any, are they doing anything against that? Or
once that
towards-
is set aside, Lordship, once
Yes.
that is set aside,
Hmm.
he must be treated as a bona fide member of his village, Lordship.
Yes, what
In-
they have
In
done.
all aspects, Lordship.
Hmm.
Now, that is not being done, Lordship. He continues to be treated as a pariah and as an excommunicated
What is
member.
that? What is that?
Now,
What is that, Paria?
they, Lordship, they are not collecting membership from him because
Not collecting?
membership. Firstly,
Ah.
because a citizen of a village, he is required to give a certain amount of money, Lordship, as
Whether, have
annual
they
membership.
refused, have they refused to accept when he pay?
No, Lordship, it must be collected. Because for that collection, Lordship, for that collection, particular person is appointed by the village or by the
No, no.
by the unit, Lordship.
No, but even if they have not collected also, for the first time, have you deposited, have you given them offered?
No, Lordship. They must come and collect, Lordship. That is what, because in all other families, Lordship, if we are all members, Lordship, then
Are they
that
saying,
collection-
are they saying that you are no more member here? No
No.
more member?
No, they are not collecting my membership,
Then-
Lordship. Then, Lordship, now if we are all members,
Hmm.
if if my friend here, if he is appointed to be the collector, Lordship, that is called as Tanupur in that dialect, Lordship. Now, he will collect from each and every member, Lordship,
Yes.
by going house to house, door to door, or by making telephonic calls, or by receiving the payment by GPay, Lordship, by whatever mode it is, Lordship. But it is his duty, Lordship, to go from door to door. That practice is prevalent in each and every village, because this particular tribe, Lordship, I am also a member of this tribe, Lordship. Even if I am from different village. So that practice is common in all the villages, Lordship. Now, that is not being done, Lordship. Lordship, see, Lordship, I don't know, Lordship, whether my Lord understands, Lordship, the social practices and the ramifications of such things here, Lordship. Because, Lordship, I will not come before this honorable court just to waste this honorable court's time, Lordship. I am approaching
No,
this
because
honorable court,
I-
Lordship,
because
because I have
initially-
pressing concerns, Lordship.
Initially.
My
see,
fundamental rights are being thrown out to the wind.
The village authority has passed some order excommunicating you, but then court was restored. But
Yes.
Thereafter,
Thereafter, I have
thereafter-
written letters. Notice has been served upon the respondents that the excommunication has been quashed and set aside by this honorable court. Now, once that is quashed and set aside, Lordship, all those informations, Lordship, and collections, collections, Lordship.
the information is given in general way, I think,
See, Lordship,
by
how
notification,
then, Lordship,
etc.,
then,
because-
then suppose if my villagers are having a meeting, Lordship, if we are having a meeting, Lordship, and if I am assigned to give information to all my learned friends here, if I don't tell the learned public prosecutor, Lordship, then how is he supposed to know? Because, Lordship, it has to be either by newspaper publication, Lordship, if it is a public notice.
Yes, yeah, to constitute this contempt, and probably in an initial stage, because they think that they have excommunicated by directly, indirectly, they are trying. Knowing that is probably is a duty upon you also, that you have not collected my fee, please collect.
I have done that.
And if they
I have done
refuse-
that, Lordship, I have
if
done that.
They refuse, then of course it will constitute.
Lordship, see, Lordship, I have done that, Lordship.
Where is it?
Lordship, it is a negative fact, Lordship. I have made telephonic calls. Why are you not coming to my place? But it seems the person who has been assigned to make the collection, Lordship, because it is not the chairman who will be
In
collecting,
order to
Lordship.
make out your case, probably you may,
There is
in the
specific-
initial stage,
There is
It is-
specific instruction from the respondent number 2, not to make collection from me.
No.
I have also stated that, Lordship, in my petition, Lordship. I have made a specific stand. There is specific, that means, Lordship,
in order to bring it on record, probably you may have to write. Yeah. And then you may have to write to deputy commissioner or to issue some instruction,
I have annexed all
So-
those, Lordship,
all those activities.
Lordship,
activities
annex of 4,
related to-
annex of 4, Lordship.
So apprising all these negligence or neglect done to you, you have to apprise deputy commissioner.
Yes,
Because
Lordship.
deputy commissioner is
Lordship, can
appointing,
you turn to page 36, Lordship?
deputy commissioner is appointing authority.
Yes, Lordship. Page 36, Lordship. Page 36, this is the signature of the Deputy Commissioner's office, the seal and signature, Lordship. They have received, Lordship.
No, so notice receives. So now you have to make a request to the, probably, because there was no direction to the deputy commissioner also to issue such order. So probably. you
Now,
have to-
Lordship, now, if I am the appointing authority,
Hmm.
Lordship, under the law. Now, if my delegate, that is, the person whom I have appointed, Lordship, if they are violating the fundamental rights, Lordship, of another citizen, Lordship, then is it not, even without any direction being given, Lordship, and when that is brought to the notice of this honorable court, and when there there is already an order passed by this honorable court, Lordship. Is it not the duty, the bounden duty of the Deputy Commissioner to ensure that the court's order is implemented in letter and in spirit?
No, there's no specific direction as such. Only
No, Lordship,
only
but
the order was set aside and passed.
yes.
No direction to issue such any notification order
Lordship, no,
letter.
Lordship, even if such direction is not there,
So,
Lordship.
Now you see, now they are they are
Once
not
this
supposed.
portion set aside, it goes without saying that he must be treated as a bona fide member of that community, Lordship, of that village, of that union, Lordship. And when that has already been brought to his notice, Lordship, even then, Lordship,
Certain thing which is
And
not
Lordship-
directed, you
Lordship-
cannot just, you cannot just compel person to do something. No. So there was no specific direction to issue letter or to do something. So under the circumstances, you see, the contempt may not made out. So in order, so that is why I'm saying, in order to make out your case, so if they start neglecting what you say is indirectly, so you just bring it into the notice and ask for, and if in the case, if they refuse to do, then only, of course, it will make out. But otherwise, do not find the violation of the orders.
Lordship,
Because you
Please,
have also
Lordship.
not shown that you have asked them that this was done to you or not done to.
Lordship,
you.
then when does contempt arise, Lordship? Contempt arises when there is a deliberate action, Lordship.
There was no action.
Why?
Where is the action?
Lordship, because Lordship, as I've been saying, Lordship Bekali, let's go in that case, Lordship.
Anyway, what we'll do, although. Okay, we'll issue notice for the time being, but unless you make a case, you may also face.
Lordship, if I may read paragraph 17, Lordship,
Hmm.
of the decision passed in WPC 120th, Lordship.
Para 17.
Yes,
Oh,
Lordship. Paragraph 17,
17 of the judgment.
page 25, yes. To my contempt petition.
Yes.
The fact situation obtaining in the case in hand are similar to the one involved in Mayang Lima Supra. There is an already decided case in similar decided case, Lordship. The petitioner herein by the impugned order dated 16/2/2023 was first temporarily debarred from being part of Chongtia village. And by the subsequent impugned order dated 30/6/2023, the petitioner has been debarred and excommunicated from the citizenship of Chongtia village for a lifetime by the respondent number 4, Chongtia Meten Changar Putumentan. This is the Chongtia Village Council, Lordship. Stop. As the respondent number 4, the Chongtia Meten Changar Putumentan, being a body amenable to the writ jurisdiction under Article 26 of the Constitution of India, the legality and validity of the impugned orders are definitely within the scope of judicial review under the writ jurisdiction of this honorable court. The power of judicial review under Article 26 of the Constitution of India to issue a writ in the nature of certiorari is available when subordinate tribunals or bodies or officers act wholly without jurisdiction or in excess of it or in violation of the principles of natural justice or refuse to exercise a jurisdiction vested in them, or there is an error apparent on the face of the record and such act, omission or error or excess has resulted in manifest injustice. Stop. As the respondent number 4, that is the village council, Lordship, does not have the power, authority, and jurisdiction to pass an order to excommunicate and debar a native within its jurisdiction, either temporarily or permanently on the pretext of enforcing customary laws. The impugned order dated 16/2/2023 and the impugned order dated 30/6/2023 are found to be passed in excess of its power, authority, and jurisdiction of the respondent number 4, and the same thus are liable to be set and quashed aside. The impugned orders are found to have been passed in clear violation of the principles of natural justice, as the petitioner was never afforded any opportunity to represent his case before passing of the impugned orders. In such view of the matter, both the orders, that is, order dated 16/2/2023 and the order dated 30/6/2023 are set aside and quashed. Stop. As a corollary, the petitioner can remain in his village and he cannot be subjected to social boycott, expulsion from Chongtia village as directed by the respondent number 4, Chongtia Village Council, that is Chongtia Matum Changar Pudumantan.
Yes.
Yes, Lordship.
Now whether they are disturbing you.
Yes, Lordship. Now, when I am not excommunicated, I must be treated as a bona fide member, Lordship. I am not saying that, Lordship, trumps must be
Your
played,
only allegation
Lordship,
probably is.
as then I must be welcome as a chief guest, Lordship, in my village. I'm not saying that, but as a bona fide member, as an ordinary member, as an ordinary citizen of the village, what is being made available to ordinary citizen of my village, that same benefit, Lordship, that same action, that same measure must also, yardstick must also apply to me. That is all, Lordship. But that is not being applied, Lordship. Me as a citizen of my village, Lordship, even if I'm being treated as an excommunicated member, I don't want to make quarrels, Lordship.
No, that is why you see, there is no specific direction. As only the court says that there will be no social boycott, expulsion from. the
Yes,
village.
Lordship.
So
Yes.
that is probably,
Now, boycott, Lordship.
he is in the village only.
No,
So
Lordship, he is not in the village, Lordship.
why not in the
He
village?
is in Kohima, Lordship. And when,
But he is allowed to stay in the village now.
Lordship, now see, Lordship,
Hmm.
in Kohima, suppose if I am from Chongtia village, Lordship,
Hmm.
then we have members of my village in Chongtia also, Lordship. Here, there is a sub-unit, Lordship, of the Chongtia villagers. That practice prevails in almost all the tribes amongst the Nakas, Lordship. So that village also functions under on the instruction aid and advice of the village council, and it functions as a subsidiary unit, Lordship, at the district townships or wherever it is, Lordship. So now here also, Lordship, I am entitled to be treated as a member, Lordship, by collecting membership fees, Lordship, by giving me information, Lordship, when villagers meetings are being held, Lordship. Well, Lordship, these have far-reaching consequences, Lordship. Now, Lordship is asking me to prove a negative fact, social boycott, Lordship. Lordship is well aware that negative facts are very difficult to prove, Lordship. And Lordship, the instructions that the federating unit receives here in Kohima, Lordship, it is only through the telephone, Lordship, or through verbal instructions.
See,
If it was on paper,
see
Lordship.
their reply, page 37. There is no practice of issuing invitation to individuals. All it's except public notice. So that
Lordship,
public notice.
Public notice, if it is public notice, Lordship, then let it be produced before this honorable court. Because there is no public notice. What does public notice mean? It must be, public notice must be published in the newspapers, or it must be broadcasted on the radio,
So
or on the
expecting that in under such circumstances.
Lordship, now,
You should
Lordship,
be
now, Lordship.
informed, the person should come to you and inform, that will be difficult.
No, it is not
There is
difficult.
no
That is the
national
practice,
access.
Lordship. Lordship is not, Lordship, I am saying, Lordship is commenting on these things without being aware of the social practices here, Lordship.
Let us see what they say, they have to say. Mr. Satyam, land counsel for the petitioner. Staff. The petitioner filed this application under section 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, for willful and deliberate non-compliance of the order dated 21/3/2024, passing WPC number 128/2023. By this court, stop. Issue notice. Returnable by 4 weeks. The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. Start. List this matter after 4 weeks. Okay.
Apply. Lordship, if it can be 2 weeks, Lordship. Because if I'm allowed to take steps by registered AD as well as trustee, Lordship. There is urgency in this case.
Okay. Then step within 2 days,
Yes,
and then to be returnable by 2 weeks.
2 weeks, Lordship.
2 weeks, okay.
By
And list this matter
registered
after-
AD as well as by trustee, Lordship.
By register. Post with AD as well as trustee. Sorry, the trustee is also allowed. Trustee service is also allowed. Okay. List this matter after 2 weeks. Okay.
Lordship,
Hmm.
if off the record, Lordship,
Yes,
if I may be allowed to,
yes, well,
Lordship,
it's,
this is off the record, Lordship. Amongst the petitioners, let me say, Lordship, there is a practice, Lordship, in many villages in Nagaland, Lordship, where during elections, consensus candidates
okay.
are being selected
Especially
by,
during election.
yes, are
Okay.
being selected by the village council, Lordship.
Okay.
So if I am selected as a village consensus candidate, then and nobody else from my village is being allowed to contest, Lordship.
Oh,
So, and if anybody goes against that and files his nomination, Lordship, then these people are excommunicated, Lordship.
oh, that
So,
technique.
this same thing happened to me also, Lordship. Former registrar of this Honorable High Court at Kohima bench, Lordship, he was also meted with similar treatment. He also
That
approached
is
his
what I'm
honorable.
saying, that is
Yes.
what I am saying, since there is no
Lordship,
specific direction.
So, Lordship, well, Lordship, this has symbolic significance, Lordship,
Okay,
Lordship.
maybe.
Because Lordship, this has Lordship far-reaching consequences, even not for just only for the petitioner, but for the future generations after Nakas also, Lordship.
That is why I'm saying, because in such case, it's very difficult to make out case. You can't compel the
Yes,
person to
Lordship.
do
Yes, Lordship. Yes,
something
Lordship.
if he is not doing. So
But then
in
again, Lordship,
under circumstances, what best you can do is that just supposing a DC deputy commissioner here in this case is also, of course, not connected what he says in earlier.
Yes.
So can also write a letter apprising deputy commissioner that since this authority comes under you,
Yes,
issue
yes.
notice that all the circulars should reach to you, or you should be informed.
yes, Lordship.
So that one letter written to them, that what instructions should be issued to this authority.
Yes, Lordship. And
That
I
should
have,
be done.
yes, I have also written to
Because
to
you
both
know,
the
you know
respondents.
what are those things which you are entitled, which are
Yes,
supposed to inform by the.
I have written to both the
Diligence.
respondents, Lordship,
Hmm,
who are included here, Lordship.
hmm.
And I have also written to,
And to the village authority also, if supposing you come to know that some meetings were convened, but then you were not informed, my neighbors have been informed, I have not been informed, then you know, write a notice. So here you have informed here, you did not inform, so kindly inform me, writing. No, that has
Lordship,
not
it's
been
there,
provided to me.
it's there in
And
Annexure
next,
3,
hmm.
in Annexure 3, Lordship.
So that probably
Yes.
is talking about a public notice.
No, Lordship, no.
Anyway,
Lordship.
okay.
For motion, item number 3.
Yes,
Please, Lord. This petition is filed under section 482 of the CRPC for quashing of this FIR number 66/2023, Lord. Dated 27/11/2023. This is a joint petition, Your Worship, by the accused and the complainant.
case, what is the status of case?
Summons station.
Hmm?
Summoned. Summoned.
Charge is submitted.
No, Lordship. Still it is some.
What is the allegation? Offense involved?
409.
409, 420, and 34 of the IPC, Lordship.
This is still under investigation.
Yes, Lordship. Although, compromise, it has already been taken place, Lordship. Settlement has already taken place, Lordship. Between
What
the
is complete?
parties. Settlement.
Settlement.
Yes,
There is a
Lordship.
settlement between the
Yes.
accused and the complainant.
Yes, Lordship.
Okay,
Jointly, they have filed the instant petition.
Yes.
but then you see, this is still under investigation
Lordship.
stage.
Lordship, so Lordship, notice may be issued. This.
Okay. Sir, Mr. Very, very, no?
Lordship.
Planning counsel for the petition. Sir. I have also heard Mr. Jimomi, Dana PP, for the state of Nagaland, staff, para. Joint petition.
Yes, Lordship.
Okay. The petitioners jointly filed this application under section 482 of the Code Criminal Procedure 1973, praying for passing of FIR number 66/23 dated 27/11/2023. Suburban Police Station, Dimapur, and the criminal proceeding of, where have you mentioned the section? Register under section, just in FIR number so and so. Dated so and so, Suburban Urban PS Station, Dimapur, register under section. Where is the section? 409.
Page 19.
420, 34 IPC. And the criminal proceedings. So you said that the case has not yet been charge sheeted.
Yes, Lord.
You have mentioned criminal proceeding under GR number. And the criminal proceeding of GR numbers 770/2023 staff. No? Issue notice. Returnable by. Which districts you said?
Dimapur.
Okay, Dimapur. Returnable by 3 weeks. 3 weeks. Okay, start. Call for the case that is not yet submitted, charge sheet.
Lordship, that I'm not aware.
Okay. Call for the case diary. Since Mr. Jimomi has accepted notice on behalf of the respondent, no formal notice required to be issued. List this matter after 3 weeks.
Lordship. In the meantime, my interim prayer may be considered, Your Lordship.
What is the int? No,
Case
what?
number 14.
No, we do not know proceeding, but then let us see,
Lordship.
what is the progress?
Lordship.
Hmm.
Black.
In this investigation, it's difficult to stop.
Bless, Lord.
For admission, item number 4.
Lordship, the last order that is on 9/7/2024.
Yes.
I was given time to address the court on the issue. So, Lordship, the order says that partial the last order, Lordship,
Yes.
substantial compliance of the judgment order dated 5/7/2023 passed in writ petition so and so has been complied. That has been reflected in the order. However, what has happened is the respondent authority, who are the appointing authority, have submitted the name of the petitioner and another one to the Home Commissioner for approval of their appointment. That is on 4th June 2024. Now, Lordship, till that, nothing has come out of it. And so Lordship, justice, has to be done and not ought to be, seems to
Not
be
only
done.
this.
So, grant some time to the respondent to, I pray before this honorable court, in a contempt case, the petitioner was given, the respondent were given 2 months to consider the case of the petitioner, Lordship. My father died in 2016, Lordship. And now 16 is already 7-8 years, going to be 4, 5, 7-8 years. So I pray before this honorable court, the respondent may do the needful and place the appointment order full compliance to be placed before this honorable court. Until then, Lordship, I pray that this contempt matter may be kept pending so that the respondent government will comply with the direction of this honorable court, Lordship.
So you are enlisted under, as per the seniority list?
Two.
Petitioner is
Two.
serial
One
number
has
two.
already been given?
No,
we have
both
sent a,
of them,
we
they
have
can-
sent a proposal to the government for appointment of the serial number 1 and 2.
Okay.
So
it has
in the
not yet
last
been done?
occasion, yes, in the last
it
occasion,
has-
furnished a copy of the letter that
Yes.
4th June.
4th June.
Yes, ma'am.
Can there's some
So
other,
this
which one?
cannot be considered as already complied with.
From the side of the contenders, we have already sent the proposal to the government for appointment, my lord. Now it is
Okay.
up to the, once the approval arrives, we'll issue the appointment order, but my lord, this contempt petition is between the court and the petitioner only. But
Yes.
as far as the contender is concerned, we have already complied with the order of this honorable court, man.
No,
Okay, but the
Lordship,
appointment not yet,
Not yet.
appointment,
not yet issued.
no,
It
appointment
will be
is.
subject to
will
the
be-
approval of the government.
Yes,
So approval is awaited.
Yes.
approval is awaited, so Lordship,
But
till-
from our part,
otherwise, if this is closed,
Hmm.
then Lordship, they will go another, even if they don't approve also, it will go again more than 2-3 years also, Lordship.
well,
So,
if the government rejects, then
no, that
that
is,
is not within our control, my lord.
no, they may not, they may or may not reject, but when there is a scheme, how can the government
So
reject
that's
it,
why we have
Lordship?
sent the proposal, my lord.
So proposal is already sent.
Miss Judge Jimomi, Lana counsel for the petitioner. And Mr. N. Longkumar,
Yes, my lord.
Lana, counsel for the, for respondent number 2, start. The Lana counsel for the respondent number 2 submits that. Has it been reflected in the earlier order?
Yes, Lordship, Lordship, you can kindly peruse the earlier order, that is 9/7/2024.
Okay,
It states, in terms of the judgment order dated 5/7/2023 passed
okay.
by this court in writ petition 115/2022, the department has prepared a list of compassionate application from 2016 till date,
Hmm.
PNAR addendum dated 9/4/2019, in which the name of the petitioner for compassionate appointment is shown in serial number 2. The respondent number 2 has also written a letter dated 4/6/2024 to the Home Commissioner, seeking the government direction approval for appointment of the respondent number 2 on compassionate ground. This court, considering the list of the compassionate application prepared by the department, in which the petitioner is placed at serial number 2, and also considering the letter dated 4/4/2024 written by the respondent number 2 to the Home Commissioner, is of the view that there is a substantial compliance of the judgment and order dated 5/7/2023 passed in writ petition 115/2022. Ms. Z. Jimomi, learned counsel for the petitioner, however, submits that she may be allowed to address the court on the issue and seeks for some time. Please sit again on 25/7/2024. So on my part, I have informed my clients and Lordship, until unless they
Issue appointment order.
yes, that will be the compliance, and this letter cannot be a compliance, Lordship. And if they don't issue the appointment order again,
Whether the serial number one has been appointed.
No,
One
for-
also still pending.
By the
Both
same
of
letter,
them, by the same letter.
we
By
have
the
sent the
same
proposal
letter.
for appointment. My lord, what happened was the person figured at serial number one.
Hmm,
He also approached this honorable court by way of a writ petition,
hmm.
and then this honorable court has given a direction.
But then, despite of disposal of the contempt petition also, the serial number one has
Yes.
also not yet been appointed.
Yes, my lord. But this,
Serial number one didn't come for contempt.
they have come, and the contempt is closed, my lord, in view of this.
Contempt against serial number one is
Yes.
also closed.
Yes, in view of this letter,
In view of this letter, only
Yes.
it appear.
which was
appeared.
issued on 14 last month only, my lord.
So now,
That is
despite
their
of the
case.
closing. Now, what will happen if the appointment doesn't come out?
That's why they
My lord,
will
but this honorable court's direction was to consider.
Hmm.
to consider this
Consider-
for appointment.
Maybe not be appointed, consider means.
So it is they who should pressurize the
Tanika,
government.
Council for Mr. Longkumar and Longkumar, council for the respondent, number one. And number two, Sami said, although in person to this court, the order and direction, they have forwarded the name of the petitioner to the Home Commissioner seeking the government direction approval for appointment of the respondent on compassionate ground. The same is still awaited.
Yes, Lordship.
However, the same is still awaited in view of the list is matter after 4 weeks. Okay, just because it's all the same disposal.
Yes, yes, yes.
So let us, because we have seen that the serial number one also file contempt petition disposed of, and despite of disposal also.
Yes, no action
Not yet
has been
considered.
taken. So what
Let
is
us-
the use of approaching
Well,
this honorable court? And this
after
is
4
the
weeks.
third
Okay.
round of litigation for
Okay.
the petition. Obliged, Lordship.
For admission, item number 7.
Your Lordship, I'm appearing for the petitioners in this matter. In item number 7.
Yes.
Your Lordship, in consequence of the order dated on 8th of July 2024, 4 weeks time was granted for the settlement talks that has been befalling between the parties. So howsoever this matter has been listed today, that is after 2 weeks. So I implore before your Lordship that 4 weeks time at least must be granted for the execution of the settlement talks between the parties. So I kindly request that the matter must be listed on, may be listed on 8th of August or 9th of August on any day.
Okay, you are Mr. Rajesh Kumar.
No, my name is Saifuddin Khan.
Hmm?
My Saifuddin Khan. Saif. SAIF.
Okay, you're for the petitioner.
Yes, my lord.
Mr. Said, then counsel for the petitioner. Submits that the settlement process has already been initiated between the and 4 weeks time. The 6 adjournment for further 4 weeks time. Stop. The prayer is allowed. List is matter after 4 weeks. Okay.
Much obliged, your lordship.
For admission, item number 9.
Please, Lordship. Appearing for the petitioners in this matter. That's the matter.
Yes.
I kindly refer the order dated 3rd of June 2024. Basically, there is a question of FIR on the basis of settlement. And on 3rd June, the respondent to a private party appeared before Lordship. In terms of settlement, we have to pay him total amount of 1.51 crores. So that amount has been paid and the statement to that effect is recorded in the order schedule. They have filed their no objection certificate also on that hearing. It was a not on record, so that's why the further questions would not be done. The order should not pass. Now, the NOC by the respondent 2 is on the record, so we have to proceed in that way. The respondent 2 has filed their no objection to the question of FIR. So,
Objection,
yeah, no objection, they have filed here.
no objection.
Yes, sir. It is referred in the order sheet. Sir.
You are for respondent number 2.
Yes, my lord.
Okay, state. Any, what is the
On last
status? Huh?
occasion, I have submitted the status report. Where it's
Status
from-
report?
Yes, yes, your
It's
lordship.
there.
Yes, I've placed it on record, your lordship.
Oh, status report, yes,
Yes, your lordship.
2 pages.
Yes. So page 3, your lordship will see that despite 3 notices, your lordship, the accused never appeared before the IO.
No, this is in the month of May.
Lordship. So no further investigation could be initiated because the accused never cooperate, your lordship.
Is there any stay?
Shall I submit, Your Honor?
Any
Lordship,
stay of the proceeding?
that your lordship, I'm not aware.
There is no stay of proceeding. Kindly refer to page 108, Your Honor. Kindly look at page 108 of the paper book.
Just a minute. I don't think there was any stay because this is in this investigation stage.
And also, there is no stay.
Okay. Then what prevents
Yes, Your Honor. Kindly have page 108 of the paper book.
any action?
This is a reply submitted.
There is no stay. Police is waiting.
There is no stay. I'm agreeing to it that there was no stay.
Just a minute, huh?
Huh.
So, this is May, the report is of May, June, July,
Yes,
some more than 2 months back, huh? Almost 3 months.
yes, your lordship.
So the latest status report is also same.
It will be same, your lordship. Because the.
How do you know?
accused-
Because if there is no stay, if the police think that it requires the presence of the accused or the accused need to be arrested,
Lordship.
why the accused has not been arrested? Police is waiting for the
accused
court to
never
direct.
appeared before the IO, whereas he's here before this court, your lordship.
My lord, if I may, I will be
No,
allowed to
there is
speak.
no protection as such.
Lordship.
Then if the police think that he is required, then could have arrested.
Lordship.
And then not doing anything but writing this before the court. Police is waiting for the court to direct. Arrest him today itself.
My lord, what happened in this case is that the matter has been settled between the parties.
Yes,
I
that
am
is
the
true.
complainant.
But then you say that that information can also be given to the police.
We are given voucher. That I mean to say. See, kindly, that's why I'm saying you kindly refer to page 108 of the paper book. The notice were issued to the accused persons.
There is
The
a
reply
paper book.
was filed. Kindly, I beg your pardon to submit, Your Honor. Kindly have a page 108. Kindly have once. The notice were issued to all the accused person, all the petitioners. They replied by way of writing, and in his own hand, the receipt was given by the investigating officer. If you have page 114, you may-
108 is notice, 108 is notice. Under 41A.
No. This is a reply to my notice. It starts with the subject is noted under section 41 in the complaint of so and so, currently residing at so and so. Dear sir, I am receipt of notice dated so and so, being referred by so
Where
and
are you reading? Where are you reading? Page,
108, Your Honor, my reply.
this is,
Yes, Your Honor.
My lord, this is a reply given by the petitioners.
The reply given by me.
yes,
So the reply was given, all the information was provided by the petitioners, and the request was made by the petitioner that we are from Delhi. So far as all the information and interrogatories can be done through VC, kindly have come to page 114. Please have 114, Your Honor.
Hmm?
No, just a sec. Please have 114. I'm reading last para. I provided all the informations in my reply, and I make a statement. Hope the aforesaid submissions and documents shall satisfy your query. In addition to that, I submit that if your good office need to do my personal interrogation to answer your any further queries, I am ready and willing to provide all relevant information and give cooperation through virtual interrogation on WhatsApp or other portal like WebEx Meet, which can be done at your kind convenience as and when desired by you. See, for the purposes of 41A, the information are to be sought. I have cooperated with the investigation order. If we commit the facts of the case, this is a civil dispute which interests the parties for the delay in possession of the plot. I have given the money in terms of settlement to him. So on the basis of that, I am before questioning. See, what is the purpose of 41? To seek the interrogatories. I have done that. And twice these replies were filed to the IU.
So where is the agreement? Settlement agreement?
This is the relevant page is 132, Your Honor. 132. I'll start with para 1, Your Honor. Shall I start, Your Honor?
Just a minute.
Yeah, please. Starts from 1 to 8. The main part is 132 and 133.
Okay.
132 says about the consideration being paid by me. The total settled amount was
Copy of this
1.51 lakh.
document has been presented to the IO of the case.
Yes, Your Honor, we have sent through WhatsApp. Here's the information of it. Even the respondent number 2 personally met and apprised with all the facts about the settlement to the investigating officer. See, the matter was heard at length on 3rd of June, and the same facts were produced before your lordship. And even everything was.
Still, you could have also asked the petitioner, your petitioner number 2.
Respondent.
For all the petitioner.
The complainant.
Okay,
Therefore.
respondent also, because agreement has already entered. You could have also requested respondent to present the copy of this to the police.
He has done that, Your Honor.
Everything, how do you expect everything can be done through WhatsApp? WhatsApp errors, WhatsApp notice, WhatsApp reply. How do you expect?
No, Lordship, I'll take other way. Physically, the respondent number 2 appeared before.
Physically, respondent number 2 at least can present the.
He has given that, Your Honor. That I mean to say, he has given that. Physically to the investigating officer, the agreement was given. Can we have information from my learned friend? They appeared physically. See, we are from Delhi, the product released in Delhi. Yes, but
PP, what more you want? Because the informant himself has appeared before the police, presented this agreement also, and he wanted express his willingness to withdraw.
Your Lordship, without using the service of the police, this could not have been happened to the Lordship. But since it has come to that conclusion, I leave it to you, Lordship.
yeah, objections are just for sake of objection. My Lordship doesn't mind. Because the number of odd judgments were on the basis of settlement. If we refer to B.S. Joshi's judgment, on the last date of hearing also do refer. It categorically says the court has ample power under 482 quash such kind of proceeding, being a private dispute between the interested parties, and
Have you
respondent
submitted,
number 2 is cooperating with me. He is not objecting.
in the
He is
last,
not
have
objecting.
you submitted the judgment we are referred to, which you are,
Yes, Honor, B.S. Joshi's judgment I have submitted on the last date of hearing on 3rd of June.
do you have the copy?
No, I don't have many.
It's not there.
Yeah, in the due course, I'll file it, but the judgment says given there are disputes of private nature to meet the end of justice.
You have the copy.
Jitendra
No.
Raghuvanshi.
Just a minute.
And B.S. Joshi.
Oh,
The
is
second, Raghuendra. B.S. Joshi, please.
Oh. Para,
Let's have page 2 of the judgment. Yeah.
para,
Para 5. It started in state of Karnataka versus Al Muniswamy and others. Considering the scope of inherent power of question under section 482, this court held that
Miss
an
Ma-
exercise.
Close of the matter. Okay. I'll
Yes,
pass. You are Mr.
Kamal Rathian. I'm sorry, I physically appeared on 3rd June. Today, we are from Delhi, so that's why we are appearing through basically.
Mr. Kamal Rathi, Learned Counsel for the petition. Also had Ms. S. Merilana PP for the state of Nagaland and Mr. V. Vinoka Achunu, Learned Counsel for appearing on behalf of the respondent number 2. Okay, so the order will be dictated, huh?
Please, Your Lordship.
Give it in the chamber, huh?
From the supplementary cost list for admission, item number 26.
Yes. indeed.
This is the latest status report, which I received yesterday, Lordship.
Okay, this is ABM. So he appeared, it appears.
Yes.
Only a little bit of appearance is required. Okay. Mr. Medaviro, Learned Counsel for the petitioner. I've also heard Mr. K. Angami, Learned PP for the state of Nagaland. Stop. Para, huh? Para 1, apprehending his arrest in connection with Twenson PS case number 16/2024, registered under section 420 IPC. The accused applicant filed this bail application. Filed this application under section 438, seeking pre-arrest bail. Stop. Para. By an order dated 16/4/2024, while calling for the case diary, comma, the petitioner was protected by an interim and his interim order directing for his release in the event of his arrest in connection with the above PS case on execution of a bail bond with certain conditions. Stop. Para. The Lana PP submitted a status, the updated status report and I perused the same, and I have perused the same stuff. As per the report, the accused, as per the report, after obtaining interim anticipatory bail, the accused applicant had appeared before the IO of the case on 29/6/2024.
28.
It says 29. Appear before the investigation agency on, just, okay, 28/6. Okay, 28/6/2024. Stop. On his such appearance, the IO had recorded, examined and recorded his statement under 161. CRPC. Stop. And since the accused was cooperating with the investigation getting agency, the IO did not felt sorry, the IO did not arrest him. However, after completion of investigation, the IO has submitted the case into charge sheet. Against the accused for offense under section 4, to face trial for offense under section 420 IPC. Start. It is further submitted that in view of the above, the custodial remand or interrogation is no more of the accused applicant is no more required. Stop. In view of the above, and since the accused is cooperating, accused has cooperated with the IO of the case, and the case has already been submitted into charge sheet, the custodial remand and or the custodial interrogation of the accused applicant may not be recorded now. require, any further custodial, remand or custodial intervention may not, no more required, Stop, in the instant case, stop. Accordingly, the considering the above and considering the above, and in view of the submission made by the Land Council to the Land TP, the interim anticipatory bail granted to the accused applicant on 23/7/2024 is hereby regularized and made absolute with the same terms and conditions. With the further condition that the accused shall appear before the trial court regularly. Stop. With the above this this application stands allowed and dismissed. Okay. Allowed and disposed of. Okay.
Obligation.
For orders, item number 11.
May I bless your lordship?
Yes.
I'm appearing on behalf of my senior, Mr. Supungwati.
Hmm?
I'm appearing on behalf of my senior, Mr. Supungwati.
Appearing on behalf of
My senior, Supungwati.
petitioner. Okay, what you want?
I pray that matter be listed on Monday.
Hmm?
Matter be listed on Monday.
Monday. Why Monday? Have you taken steps upon the newly impleted,
Yes,
taken steps?
yes, your lordship.
Okay. The Land Council for the petitioner, Miss
Disigno.
submits that she has taken steps upon the newly impleted respondent parties. The return service report is still awaited. In view of the above, this is matter after 2 weeks. Okay.
Yes, your lordship.
For orders, item number 12.
Yes, I can.
It appears the steps upon all the respondents have been affected, lordship. Respondent 2 and 3 had also appeared on the earlier date, lordship. For respondent number 2, Vizimo, my learned friend, has appeared. And for respondent number 3, learned government senior advocate, Mo Mchin has appeared, lordship. And I have reliable information, lordship, that for respondent number 1, Enangami shall be appearing.
So,
On behalf of Mr. Anangami, my colleague, can grant some time to obtain instruction for respondent number 1.
So I
Mr.
have no,
Santingan,
yes,
Land
I have no objections to the
okay.
prayer for adjournment.
Mr. Santingan, Land Council for the petitioner is present. So, Mr. Anang, you are appearing on behalf of?
Mr. Anangami for respondent number 1, Lordship.
Okay. Angami Land, appearing on behalf of Mr. N. Angami Land Council for the respondent number 1. Praise for some more time to obtain instruction and to file affidavit. So the prayer not objected. Accordingly, the prayer not objected. Accordingly, list this matter after.
Lordship, after 4 weeks, but as far as respondent number 1, affidavit may not be very necessary, Lordship.
Or not necessary.
Yes, because she's the chief
Okay,
secretary.
to obtain instruction.
Yes, yes.
Okay, who else? The others are not appearing to obtain instruction, huh? Stop. The prayer not objected, huh? Stop. Let's pray for common, list this matter after
4 weeks, Lordship.
4 weeks, Lordship. Okay.
I am obliged, lordship.
For orders, item number 13.
Yes.
Lordship, await service report upon respondent number 2.
You are miss?
I'm counsel for the petitioner. Vikono Kiso.
Hmm?
Vikono Kiso, counsel
Learned
for the
counsel for
petitioner.
the petitioner. Who is present. And Miss Mary, appears on behalf of Mary Elan PP. For the state respondent is also present. Staff. Office not dated 22/7/24 reflect that the notice in the service report with the service of notice upon the respondent number 2 is still awaited. In view of the above, list this matter after 2 weeks. Okay.
Lordship,
For hearing item number 22.
Yes.
Please, Your Lordship. This is a matter seeking quashing of cyber crime case number 3/21 registered by the Nagaland Police Cybercrime Cell under section 420, 120B of the IPC and 66D of the IT Act. In fact, Lordship had earlier heard this matter and perused the case diary also.
Okay, heard this matter.
Yes, Your Lordship looks at the order dated 22nd April 24.
You were to come with the updated CD.
So on the last date of hearing, they stated they don't want an updated CD. Your Lordship has the last order, 18th June.
18 June.
Please, Your Honor.
Little bit of fact. So this is updated CD.
Sir.
This updated CD.
Lordship, yes, there is a latest CD.
It is.
Yes, the status of the cases as it is, Lordship.
Just a minute. Huh?
Till 18th of June, as per him, the case status was same.
So you are Mr.
Anindya Malhotra.
Anindya.
Please, Your Honor.
So in the last earlier, some other advocate appeared.
Yes, Mr. Zamar was leading us in the matter.
Okay, so in the last the last order it says that.
An NOC was sought for and my wakalat was sought for.
Okay.
We have filed that.
Your file.
We filed.
The Wakalatnama.
Wakalatnama and the NOC both have been
NOC
filed.
also.
Yes.
Okay, so now. Okay. Just a minute. Yes.
Please. So on 8th of October 2021, an FIR was registered in the cybercrime cell,
Nagaland.
Nagaland.
Okay.
I am not named in the FIR.
So let us see the FIR.
The FIR, your lordship will find on page number 69. This FIR is based on a complaint filed by an advocate from Delhi.
69.
69. This is where it starts, your lordship, and 71 would be the relevant page.
71.
71, the sections are mentioned, 420, 120B and 66D of the IT Act.
Okay.
Now, lordship would see, I'll come to page 73 and read the portion.
Yes.
To Shri T. John Longimer, IPS. I'll come to the subject straight away. FIR against HPZ tokens for duping thousands of people throughout India in crores or rupees at the pretext of doubling their investment by the app HPZ Coin. Respected sir, this is in reference to the aforesaid subject. I am mindful that the Nagaland police and the administration is already occupied with regulation and enforcement of various measures being taken in the wake of COVID-19 pandemic. However, the seriousness and gravity of the illegal activities of a large group of people on online and offline medium has compelled me to file an FIR. That the culprit scammers who have duped a large number of people in the pretext of doubling the money through Bitcoin and other crypto investments by the name and style HPZ token. So lordship may take down the name HPZ token. The complaint is against HPZ token, the online trading investment, the allegation of doubling the money is against HPZ token. And lordship may take it, I have no connection with HPZ token. Now, lordship may come further. That firstly, they lured us to invest in the company. Then they asked us to join other at the pretext of incentive for the new member. That the modus operandi of the scammers is as. I heard about this HPZ giving a good daily income. And I saw that the total income was more than double. And also we are lured by many known friends who induced us to invest in the app. So I downloaded the app and invested, but the income I withdrawn from the app is not coming back. So the website is given below, your lordship may see at the bottom itself on that page, HPZ token. This is the website from where they registered. Now, next is that screenshot in the complaint of the app. Now, lordship may have page 75. The bottom two lines. That a close look into the transfer into various accounts seems to have been credited by the company named Lilian Technocap Private Limited. So, lordship may take down another name. Lilian Technocap Private Limited. So these are the two names which will figure in the FIR. And lordship may again take it, I have no connection with Lilian. HPZ token and Lilian. These are the only two names. Now lordship may come to the next page, page 76. That we were also lured to join as many people we can through the incentive program, which was as invite friends to join 3,700 rupees to get 300 rupees rewards, add new members to get 300 rupees, upgrade to 3,700 to get 300 rupees, invite friends to join 8,700 rupees. So this is the way you invite people and you earn money. This is the aspect. Lordship may come to page 77 now. In the middle paragraph, the first paragraph is again the same, the invitation. Now, lordship may see last week, they clearly noted that we will get our withdrawal on 15th August 2021 and on 14th August 2021. They told us to withdraw before 15th August and we will get the income on 16th August. That is today, but not a single one of us had got it. And also they told us to pay 5,000 as to be a valid member. We did that too, and none of the admin is active in WhatsApp now, nor do they pick our calls. that the link of effective member group is those who paid more than 5,000. The link is given below. That the following communication sent by the HPZ will make it crystal clear on how they are forcing us to invest more and freeze our account so as we cannot withdraw our money. The next is their announcement, Lordships. Currently, due to many members, we currently work more than 24 hours a day and still cannot process all orders. Therefore, banks are now required to assist in opening the VIP withdrawal channel to satisfy many hardworking members. VIP withdrawal time 10 minutes to arrive. Next is join VIP withdrawal channels as follows. If your device exceeds 17,700 rupees, please notify me immediately. You can join the VIP withdrawal channel immediately. Invite 3 more than 17,700 members to join VIP withdrawal channel. If you do not have a VIP withdrawal channel, you need to wait 48 to 72 hours to reach your account. If you do not receive your account within 72 hours, please consult me immediately. I will help you withdraw money quickly. Please note, now we need to distinguish between valid members and invalid members. So please recharge 3,000 rupees. No need to read equipment. I will contact you proactively according to your order and invite you to join the new advanced working group. For valid members, please click to log out before 12 on August 15 and everyone will receive bank payment on August 16. Please withdraw cash only once on the same. Example, if your account balance is 1 lakh rupees, you can withdraw at one time. Do not withdraw multiple times to increase your workload. After 12 on August 15, the account of invalid member will be directly suspended and the company will no longer hire the member and will not do any asset liquidation. Don't ask me about withdrawals. I won't answer you. I'm really dealing with all effective members. If you want to withdraw the entire balance, you want to continue to make money in our company. So now is the time to test. You only need to recharge 3,000 rupees and I will give you a red envelope of 3,000 rupees. This process is mainly used by the finance department to determine whether you are a valid customer. If you do nothing, then we will freeze users who have not recharged on August 15 and they will not be able to log in. Our company makes a lot of money for everyone, but the reward is hurt and distrust. So this is not forcing. If you want to continue to make money, please take it seriously. HPZ will always exist. If you have already recharged, please ignore this message. According to statistics from the Ministry of Finance, 67% of the members have successfully joined the effective member group and all the balances can be withdrawn after August 15. If your subordinates have not yet activated, please notify them immediately. Before August 15th, we will stop accepting valid members. After that, the member accounts that have not recharged 3,000 will be permanently frozen. You may not realize the seriousness of the problem. The company is determined to eliminate invalid members this time. Even if you recharge millions, if you have not completed the recharge of 3,000 rupees, the system cannot judge whether you are a valid member. Your account will be directly suspended and cannot be lifted. Once the account is frozen, you will have nothing and can no longer withdraw funds. If you have completed the top-up, please check if your withdrawal has been returned to your balance. Notify. The bank will reject all withdrawals today. At 12 tomorrow night, members who have already topped up 3,000 rupees can start to withdraw all of them. It will reach your account within 24 hours. At the same time, friends who have not topped up 3,000 rupees will permanently close your account at 12 tomorrow night and cannot withdraw cash, cannot log in again. You don't need to reply if you have completed the recharge. Second latest notice. Yesterday, we received a notice from US Securities that our company currently needs to pay 50 billion rupees in taxes. So from now on, each member must pay 10,000 rupees to enter the effective membership team. At the same time, members who have completed the recharge must pay 7,000 rupees immediately. Otherwise, your account will be permanently frozen, but our company will give you a bonus of 10,000 rupees as a subsidy. Finally, I will tell you that before tomorrow is the last chance for each member. After tomorrow, you can sell all the equipment back to our company and get all the withdrawals. You can choose to continue laying machines to make money, or you can leave our company. But now you have to complete a recharge of 10,000 rupees to become a valid member. Please remember that members who have completed 3,000 must submit 7,000 rupees again. This is a requirement of the government and the US Securities Regulatory Commission. If you do not recharge, the account will still be closed at 12 tonight. Notify. Members who have not recharged need to recharge 10,000 rupees immediately. Members who have recharged 3,000 rupees must now recharge 7,000 rupees. You can choose to recharge or not to recharge, but members who do not recharge tonight will definitely be blocked. So it will be difficult for you to recharge in the future. If you have topped up 10,000 rupees, please submit the withdrawal form at 12 tonight and we will reach your account within 24 hours. Please remember that even if you top up 3,000 rupees before you cannot join this, this is the latest notification, but you can rest assured that there will be no additional amount. You can take a screenshot and I can assure you, but this is the last chance. The account will be frozen after tomorrow. I will not let you raise a penny, lose a penny. You top up 10,000 rupees today and I will give you 10,000 rupees and you can withdraw at 12 tonight. Our company is preparing to go public. Due to the inconvenience caused to you by tax adjustments, some black sheep think that the company is going to run away. At today's company executive meeting, I firmly oppose the company's decision. I have always tried for the best interest of the members in my area. Do you think that if I eat your money, your conscience is eaten by dogs? I say it one last time. Members who have recharged 3,000 rupees, now you can become a valid member. All withdrawals will arrive in your account on August 16th. I collected everyone's opinions and many people cannot accept 7,000 rupees. Become a valid member now. 7,000 rupees will be supplemented by myself for you. If you don't recharge today, if you don't complete the recharge of 3,000 today, then you will not be able to get your withdrawal. Last 4 hours. If you have not joined the effective member group, after 12 tonight, you will be fired. Those who are expelled won't get a penny, cannot withdraw cash. If you have not topped up 3,000 rupees, your account will be permanently frozen at 12 tonight. Lost the opportunity to make money. Now, your Lordship may see. No need to reply if you have recharged. Group admin number in WhatsApp. So these are the group admins who were there in the WhatsApp sending these messages. Lordship will see there are about 7-8 of them. And Lordship may again take note, I am not in the group admin. I am not part of this group admin who's running this group. Now, Lordship may come to the next page. These are again screenshots of those apps on page 84. 85 is again the HPZ token, how it is done. 86 is the conclusion. The complainant who have invested into the company are as below. They are from all over India and are mainly from northeast states of India. That I advocate Vishwa Kumar Jain, enrolled with Bar Council of India, practicing in Delhi Court. I was approached by people to file an FIR since the number of victims are many and are mainly from remote place of northeast India. And the whereabouts of the scammers are not known. We are filing the FIR in different states. The complainant besides many is detailed below. So the details of the complainant, your Lordships will see, is at page 86, 87, 88, 89, 90, 91, 92, 93. Lordship may come to 93. The bottom part, where the name of the complainant sent. Name Lebozing Osle, Dimapur, Nagaland. He and his family had invested almost 26.5 lakhs. The number are many who have invested. We are collecting the details and we will forward you all the names and the amount spent. We kindly request you to understand the urgency of the matter. These scammers are still live and can be caught if prompt actions are taken against them. That the total number of complaints sent to my email ID is more than 500 from Nagaland, who has been duped, and this amount may go in crores. That for the scarcity of time and the urgency of matter, I am not enclosing all the name. That the total number of email I received from Nagaland is more than 548 hours, and the number will go beyond imagination. Kindly look into the matter, sir. This is the complaint filed by an advocate from Delhi, which they convert into an FIR. The complaint as it is reproduced in the FIR. Only two names Lordship has taken note of. HPZ token and Lilian Technofab. These are the only two names coming forth in the FIR that we invested into HPZ tokens. The passwords, the usernames, all were there in HPZ tokens, and the money seems to have gone from HPZ tokens to Lilian Technofab. Now, Lordship will see the other group members, also the admin members, which I showed. I am not there as well. The petitioner's name is Bhupesh Arora. So in that list of admins, which I showed to your lordship on page number 83, the WhatsApp group admins on 83, if your lordship sees that, the screenshot is annexed. My name is Bhupesh Arora. I am not a part of it. Neither is my mobile number a part of it. Now, only 3 aspects in the FIR that I pointed out to your lordship, which can identify somebody from the FIR. I am not a part of that process. I cannot be identified through these 3 entities. Now, how I come to know about this FIR? And lordship may also take note, from the date of registration of the FIR in October 2021 till date, I have not been served a summon from the Nagaland police to join the investigation. We are in 2024, almost a period of 3 years. They have not summoned me. They have not served me a notice to join investigation or to produce any documents. Now, how I come into knowledge of this FIR, lordship, that's important for your lordships to know.
Yes.
So lordship may, for a moment, have a look at my list of dates for your lordship's convenience in the beginning. That will be the 3rd page of the petition after the synopsis. It's a small tabular form.
Yes.
The lordship will see 8th of October 21, the FIR is registered. Now, lordship will see on 12th of April 2022, and ECIR is registered by the Enforcement Directorate. Now, if your lordship is aware of the process of registration of an FIR, I can brief your lordships about that also. So, an ECIR is registered by the Enforcement Directorate with regard to offences if they are notified under the Prevention of Money Laundering Act as scheduled offences. So, there is a list of offences given under the Prevention of Money Laundering Act. Like every offence under IPC, an ECIR cannot be registered by the Enforcement Directorate. There are certain specific sections which are listed in a schedule, which are called the scheduled offences or the predicate offence. If those offences are mentioned in an FIR registered by any state agency or by the CBI or by any other investigating agency, then the Enforcement Directorate has the power to register an ECIR into which they investigate. Now, they register an ECIR on 12th of April 22. On 8th of February, they conduct a search. The Enforcement Directorate. These all actions are done by the Enforcement Directorate, nothing by the Nagaland police. On 11th of October, if your lordship comes on to the next page, on 11th of October, again a search warrant is issued. And my residential premises are also searched. Till now also, I am not aware of the FIR. On 9th March 2023, they forward an application to the adjudicating authority. So there is an adjudicating authority under PMLA where they forward an application where they seek to attach assets of the person suspected of the crime under the Prevention of Money Laundering Act. So they forward an application to the adjudicating authority. On 15th of March, the adjudicating authority records its reason to believe at a finding. Although I'm reading out these list of dates to your lordship, this will not be relevant to the adjudication of the present matter, but I need to give it for the brief history of the matter. On 15th of March, the adjudicating authority says that a prima facie case is there and it freezes the documents, the accounts, and retains the documents in terms of section 17(4). Now on the next page, Your Lordship, on 16th of March, a show cause notice is issued by the adjudicating authority to the petitioner stating that why the documents which have ordered to be retained and the accounts which have ordered to be frozen should not be confirmed, and they asked me to file a response. So when I get this show cause notice on the 16th of March 2022, along with this show cause notice, annexed is the FIR. So Lordship may note today, my prayer is not to do anything with the ED. Lordship may have my prayer as well. On page 20. The only aspect why I read out to your lordships these facts were because this is how I came into possession of the FIR. Lordship has page 20. Prayer A. A writ of mandamus be issued declaring that the petitioner herein is not involved in the criminal activity, being the subject matter of investigation in Kohima cybercrime PS case number such and such. Prayer B. A writ of mandamus quashing all proceedings qua the petitioner arising out of the Kohima cybercrime case number such and such. Prayer C. Writ of or in the nature of certiorari commanding the respondents, their men, agents, servants, and assigns to transmit to this honorable court all records relating to the instant case being Kohima cybercrime number such and such. Prayer D. Writ in the nature of certiorari to call for the case diary of the instant case in connection with Kohima cybercrime case number such and such. Prayer E. Rule nisi in terms of prayer A to D above. So my entire prayer if your lordship sees the prayer A, that has already become infructuous. They have already filed a complaint. So my only prayer from A to E is against the Nagaland police who have registered a case under the Kohima PS crime cell, cyber crime cell. And because I am not named in the FIR, I have not been summoned by the police till now. I am not aware what is my role. So I am stating because I have nothing to do with HPZ token and Lilian Technofab. Therefore, no role is ascribed to me. Thus, this FIR qua me should be quashed. And it is for this reason your lordship had called for the case diary of the case to see exactly what is the role of the petitioner that the Nagaland police has ascribed or whether there is any role or not. Lordship may also come to the last page, 364 of the paper book.
If you are nowhere, why you have come?
Because there is an FIR now.
FIR, no name.
No name, but on the basis of that FIR, they've registered an ECIR against me. So that is the question. Had there been no ECIR, I wouldn't have even come to know about the FIR. So Lordship will see page 364, the last page. This is the company master data form of Lilian Technofab, who is named in the FIR. Lordship has the name, company name at the top. Second line, company name Lilian Technofab Private Limited. This is from the website of ROC, and Lordship may have the last two lines. Details of the directors and signatories. Last, bottom line. Raj Narayan, Kishan Kumar Raut. I am not a director in this company. I am a director in only two companies. I'll give those names to your lordship. Freebies and Analytic. These are the two companies in which I am a director, in which there is no allegation of diversion of funds in the Nagaland police case.
You are director of,
Freebie solution.
where do we find that?
That I'm making a submission to that effect. In my writ petition, I've stated that
Okay.
there is no allegation against these two companies. Lordship will have page 11 to see where I've mentioned that in my writ petition. Lordship has page 11.
Yes.
Roman 7. Freebie Solutions is an entity controlled by the petitioner and his father, Sri Gulshan Kumar. Lordship may now have Roman 11. Analytic Business Ventures Private Limited had transaction with SEPL. And one Shri Akshay Diwan is the director of ABPL as revealed from the master data. So
You are director of
Freebie
Solution.
Freebie Solutions, just Freebie Solutions. And it is for this purpose your lordship had summoned the case diary to see my exact role. And now a strange situation has arisen in this writ petition. I'll tell your lordship why. Instead,
You are also director of Analytics.
no, only Freebie.
Okay, why you have mentioned this Analytic?
Because these are some of the companies mentioned in the ECIR of the ED. So these are the allegations which I've culled out from the ED ECIR. And lordship may also take it that Analytic has also not received any money as per the FIR. It's only HPZ and Lillian.
But you said that you are not connected with the Analytic.
I'm not connected with Analytic.
Okay.
Now a strange situation has arisen in this writ petition, your lordship.
Hmm.
Instead of the state filing a counter
Hmm.
and prescribing my role or giving details of my role, the ED has filed a counter giving allegations against me from their ECIR. And they have become the main contesting party, which in my respectful submission cannot be permitted. Because no relief is being sought by the petitioner against the ED in this case. Any objection, any opposition, if any, has to come from the state of Nagaland.
Who is investigating the case?
State of Nagaland.
You said that state of Nagaland has, since you have not been implicated in the FIR, so whether the investigation of the case has affected you in any way?
Yes.
How?
That investigation of the case has led to registration of the DCIR. Let the state of Nagaland make a statement that I am not an accused in that FIR. I will be out of this court.
No, as per the registration of the ECIR,
Please.
you are accused.
Yes. They have filed a complaint also in the Dimapur District Court against me under the provisions of PMLA.
Separate.
Separate. The ED has filed it.
This is, the separate is not connected here.
Not connected here. It's under the Prevention of Money Laundering Act.
Okay.
It's
And
before the
ECIR
Sessions Court.
has registered against you by under what provision?
Under section 3 and 5 of the Prevention of Money Laundering Act.
And person to the registration of the case, have they done anything to you?
Yes, they filed a complaint. They've complained a formal complaint against me in the Court of Sessions.
In fact, Lordship,
I have been made an accused over there.
issuance of summons by the special court.
Hmm.
He has not brought it there.
I have already appeared. I put in appearance. That's an incorrect statement. I must submit. And
Last few days, but.
I will give my date of appearance as well.
The last date of.
No, you can give my, on the
No,
first.
no, so, what happened to the, this is still under investigation, the Nagaland police. PS
Nagaland police is under investigation.
And what
and I'll
about the
tell-
ECIR?
24th of May, I have already appeared before the district court.
Lordship, if I may submit.
Yes.
subject to what my learned friend says. The process for the ED to come in.
Hmm.
Is there has to be an FIR,
Hmm.
which discloses a predicate offense. The police will do their own investigation.
Hmm.
Now, here is a case where money is involved.
Hmm.
The ED will take its cue from the FIR and it will do its own investigations. He may not be named in the FIR.
Hmm.
A person not named in the FIR, it is not that he cannot be proceeded against under the PMLA. So while doing the investigations under the PMLA, we found him connected with money laundering.
Hmm.
And that is why we filed a prosecution complaint for the special court, where summons have been issued to him. Now, if he is aggrieved by what has been done by the ED with regard to the money laundering case, he has to challenge the proceedings of the special court. So far as the police investigation of Nagaland is concerned, they are still investigating. Their investigation will be something else. The punishment will be what? Punishment will be imprisonment. The penalty will be imprisonment. So far as money laundering is concerned, if we find that the properties that he has created, the money that he has laundered, is actually, he is involved, that will be confiscated and brought to the state. That is the purpose of the PMLA. So if at all he is aggrieved, he has to challenge the special case. And he has referred to my affidavit. I have opposed. You have made me a party. You have incorporated the ECIR. Why I shouldn't file my reply? Whatever I have found till that date of my filing of my response, I have given everything. I have shown your role in the laundering process. He says, I am not involved. I am not this, I am not that. If your lordship will see my paragraph 5 of my reply, lordship will see that he is involved in the whole nexus. Freebie, analytic, he is involved. Therefore, if at all he has to challenge the special case. And so far as the FIR is concerned, yes, he is not named, but he need not be named. He need not be named. If the police does not find out anything about him, that's the end of the matter. But now, police is yet to file its charge sheet or the FR. We have found out something. So, as per law, we have filed the prosecution complaint. Now, the interesting point out here is, he may not be named in the FIR because money laundering is a standalone offense. The person I have collected some money, I need not use it. If my friend, he will suppress that amount, he will divert it to something else. Then the offense can be attributed against him. That is precisely what has happened here. He need not be named. All these companies, HPZ, token and all, he is not personally there. He is not named. But somewhere, he is getting the money at some stage and he has siphoned off the money. He has created properties in Dubai. He is not coming back in spite of summons being issued by the ED. That was the other case, which on the last occasion was closed, WP Criminal 3. Because why will he come back? He has got all his assets. He has created assets in Dubai. Very soon, maybe he will go to the Caribbean because it's become too hot for him in Dubai. It's become too hot for him in Dubai. That is why he need not be named.
he may not be named. With our own investigation, we found out at some level he is involved. That is why we filed the
Now,
prosecution.
now your prayer is to citizen and quash the,
Now, Lordship, exactly this was the situation where I was pointing out to your Lordship, the strange situation. The prayers are against the state of Nagaland. But the state of Nagaland is absolutely quiet and the ED is stepping in. I am not raising any grievance. I am not, just a minute. just a
Lordship, we
minute.
are not silent. We are not
So
silent.
the,
We are
I am my
giving you
grievance, Lordship will see, my learned friend pointed out that if I have any grievance against the case of ED, I will take remedies against this. That I will do.
now you have made party to the ED.
ED is a performer party. I had to make ED as a, I'll tell your Lordship why I have to make ED a party. Because I've got the possession of the FIR through their ECIR. So it was my incumbent duty to make ED as a party. That would have been a concealment on my part if I wouldn't have made ED as a party. And Lordship will see on page 37 of the counter of the ED, specifically written by them, enforcement is not in a position to comment on the registration of FIR by Nagaland Cybercrime Police. They have put this on affidavit. I am not concerned about the allegations against me made in the PMLA complaint. That is not, absolutely not the concern that I have or this court should be looking into it. My concern is just what is the investigation done by the Nagaland police. And why I'm stressing on it, Lordship, was in the recent Supreme Court judgment of Vijay Madan Lal Chaudhary, the Supreme Court clearly states that if in the scheduled offense, which is the case of state of Nagaland over here, if no case is there against me, then the offense registered by the ED against me will have to go.
That would be
So
the outcome, Lordship. That is not the.
So that is not my prayer.
FIR.
That is exactly. So let's not try and confuse issues over here.
No, Lordship.
My relief is not against the Enforcement Directorate.
FIR.
My relief is purely and purely against the state of Nagaland. It is for the state of Nagaland to show that whether I am an accused in the matter or not. And if I am an accused, what is the material they have found out in 3 years against me? It is not as if they will sit quiet over the investigation for 10 years. And I will continue to remain an accused.
No, he is not even accused as of now. He's a
Let
stranger.
them make a statement. I'm not an accused.
He's
Let them make a
stranger,
statement.
as far as the case is concerned. He has no locus standi. What is he doing?
Let them make this statement that I'm not an accused in the FIR. I have no difficulty.
He has no locus standi to even interfere in
Let this statement come on record.
interfere.
No. What he is submitting is that if you are not accused, nowhere mentioned, nowhere connected, why you have come?
I'll tell your Lordship, that's exactly the point. I explained to your Lordship that the registration of the ED case can only happen if there is an offense under the Scheduled Act.
Now, ED found you,
May have found me. I am contesting that. I will contest. I will take my due process of law. Whether I have to file a writ challenging that, whether I have to defend the trial, I will take my call. But today, the state of Nagaland, based on the FIR of the state of Nagaland, the ED has registered that complaint. So from an indirect action of the state of Nagaland, the ED has attached all my assets, frozen all my assets, frozen all my accounts. If tomorrow Lordship will see the prejudice being caused. Today, the state of Nagaland, my learned friend has fairly submitted that today, even today, I am not an accused in the FIR. He has made that statement. If I am not accused in the FIR and for 10 years, this statement doesn't come on record and after 10 years, this statement come on record, I will have a remedy to challenge the ED proceedings. But for those 10 years, my assets, my accounts, they remain frozen. From an indirect action. Let them make a statement whether I'm an accused or I'm not an accused. If I'm an accused,
That
then
is
they
what
will
investigation is going on. Worship,
in the
whether
Nagaland
to
case-
find out whether he's an accused or not. Investigation goes on. He has no locus standi or right to interfere at this stage. Allow us to do our work.
Whether anything found against him in the Nagaland KPS case?
Lordship, if you may kindly turn to the pink, there's something we are finding. Lordship.
I am making a statement to the court. If the learned public prosecutor makes a statement, I am not an accused in this case, I'll withdraw this petition.
No, what
Let-
is submitting is that if you are not accused, not connected, why you have come?
Lordship may record this statement that I am not an accused.
No,
And
if you are not accused, if you are not connected, why you have come?
I told your Lordship, if
Hmm.
I am not an
So that
accused,
is
then,
what he is
then there can be no ECIR. So the registration of an ECR filing of a complaint by the ED
By the
is
sub-
giving rise to an inference that I am an accused in this case. And the moment they say I am not an accused in this case, then I will avail my remedies against the ED.
From the by the submission of the my learned friend says that as HPZ and the lieutenant of the accused, he said. So investigation is going on
Let
in the FIR.
Lordship may simply, I have a very simple solution. Let this statement come on record and Lordship may dispose it off that since I am not an accused in the case, I will withdraw this petition and I will have the liberty to approach the court again as and when if any action is taken against me.
I fail to understand.
And Lordship may dispose of this petition.
Not yet concluded. And he is harping on the FIR.
I fail to understand why ED is stepping into the shoes of the state of Nagaland.
And the police may find out many more accused persons.
Yes.
And this is exactly the reason why ED is opposing it. Because the moment the FIR goes, the ED case will go. Lordship may dispose of the petition.
Just a minute. Huh? What is the company in which you are the director?
Freebie Solutions.
Freebie. And your name is?
Bhupesh Arora.
Bhupesh Arora. So name has appeared.
Right now, my friend said my name is not there. Now, Lordship can see my name is there.
No, what he is submitting is if you are not accused, if you are not named, if you think that you are not involved, why you have come?
Lordship may simply.
What is your locus? What is he? That is what he is asking.
So I'm saying let this statement come on record. My prayer will not be there. Then the FIR will not be quashed. He will simply say I'm not an accused in the FIR at the moment.
What he meant to say is since you are connected, you are involved. That is why you have come.
Because the registration of the ECR gives me an inference. And if that inference is wrong, let that be clarified.
Tarun Arora. Seven. So the case was registered on 18
October 2021.
Still, it is under investigation. So what is the status or the position in the E? ECIR.
The
So case was registered against, when it was registered?
the case was registered on 12th of April 2020.
April 22. This is also still under investigation.
No, they filed a complaint. It's resulted in.
We have filed a prosecution complaint in the special court
Okay.
against 299
Hmm.
entities.
But then that is not under challenge here.
Not in the challenge.
Okay, so that we can't touch here.
No, I'm not even asking your lordship to touch that.
Okay. But then this is still under investigation. How do we just?
Lordship may
set
simply
aside-
dispose of the writ petition that I am not an accused in the case at the moment.
No. What
How
if,
can he say that? How can he even submit that?
no,
It's your submission, not my submission.
no.
They have
you are
to case
repeating?
and hope to-
Why you are repeating?
How can he?
What is submit is if you think and if you submit that you are not connected, not at all connected in connection with this case. You says that you are not named FIR, you are not connected with this SPZ and Lilium Technology
Technifier.
Private. And if you, so you are connected, that is why you are under investigation in the present case.
No,
So
Lordship,
if you are not connected at all, why would you have come, huh?
then your lordship may take it. If I am connected,
Hmm.
if I am connected,
Hmm.
then what is the material they have found against me till
So
now?
that is
No.
still under investigation.
No,
it is
so
still
till
under-
now, even is there even an iota of evidence that has appeared against me till now in their investigation?
Let the conclusion be concluded.
That we have been at 2.5 years under the investigation. If I am connected,
If you are innocent, stay cool, don't make
no,
the
this
effort.
cannot be an unending process that you take 10 years to complete the investigation.
But you said you're innocent, in that case, if you're
Subsequently,
innocent,
at the
why you
behest-
refer me to police investigation?
Subsequently, at the behest of Bhupesh Arora, you are Bhupesh Arora.
Bhupesh
only?
Arora.
Yes. The said deposit money was further transferred to create untraceable layer of transactions. After several layers, the money lands beyond Indian jurisdiction through Hawala route. You are also proprietor, director. Okay, statement on oath. So they said that it was you, Bhupesh Arora. And you have deposited money in their account. No, in your account, sir. So your prayer is to set aside and quasta
What's the FIR? Against me, Kwame.
Under the circumstances, it will be difficult. The case is still under investigation.
Also, there has to be a time limit. We have been almost 3 years into investigation.
What is the time limit?
There is no time limit prescribed under law,
Then,
but it's been 3 years.
hmm,
And even till 3 years, they have no, what is the basis on which I've been,
they are still changing because account after account, it appears.
Lordship has seen the case diary. After 3 years, what is the evidence? Half a page of evidence. Based on what? Merely a statement to produce before the court. I don't know what date is the case diary, but till 18th of June, the situation was the same. And suddenly from 18th of June to 25th of July, the situation, they say Bhupesh Arora is involved.
So any person arrested in connection with this case, other than this Arora, any other person?
Not the investigation will be going on, Lordship. Investigation is going on. So my prayer is,
That also sounds too slow, not yet.
yes, but we are
Going too
dealing with
slow.
some very innocent people, it appears. So they are very innocent, very smart. So this investigation
Because you see-
become very difficult, it appears, Lordship.
2021 registered, you have not done anything, only few name taken. And not done anything against them or Israel.
But Lordship, they are not even the petitioners not even aggrieved by that. He say he names to declare that he is not involved, that he wants his name to be declared as not involved, that he wants the FR to be quashed. He has not a question that SFR that is concerned.
So in that case, his submission probably is in respect of the petitioner
Yes.
to set aside and quash in respect of the the FIR in respect of the name of the FIR, the petitioner only.
In the FIR, his name is not even there. How can he interfere?
So.
Just investigations going on in the
No,
end.
so
need to be-
that is rightly
Now-
a case.
Now, what right do you have at the investigation stage to set aside and quash while the investigation is still actively going on?
That's what I'm saying, Lordship. After 3 years also, they have no evidence against me.
Now, how can you say now?
Lordship has
There
seen
is
the
no
case.
evidence against you because
Lordship has-
investigation is still going
Lordship
on.
has seen the case diary. It's for your Lordship to peruse that. I have no information which shows that.
Now the case is yet to submit into charge sheet. We will have to see what further information during the investigation the IO will find.
May I suggest to your Lordship?
Yes.
May I suggest to your Lordship? Lordship may say, as of now, there is no evidence against me or I have not been
No, I
made.
can't say, there is your name also appeared.
But now my learned friend is saying I'm not even
No,
accused.
this submission will not do. There is on record it reveals.
But have I been made as an accused over there? That's the question.
So
Whether I am being made as a victim, whether I am being made as an accused, or whether I am being made as a witness. There can be three possibilities.
stage,
Or the fourth
petition is
possibility,
coming
maybe
from
I may be let out.
what is this?
There's a Supreme Court judge order, Lordship. Page 2, Lordship. It says, paragraph 2 and 3, Lordship. It is not in dispute that the petitioners have not been named as accused in the said crime. If the petitioner have not been named as accused in the said crime, the question of stated FIR or the case under investigation by the Central Bureau of Investigation arising from the said crime does not arise, as the petitioner will have no locus standi to seek such a relief. In other words, the petitioner not been named as accused in the said crime or the case now registered by the CBI on the basis of the said crime cannot be permitted to ask for question of the proceeding concerning some other persons. It's very clear, Lordship.
No difficulty, Lordship. I'm asking a Lordship to dispose of the petition in these terms only. That I am not named as an accused in the FIR, thus I have no locus to challenge the FIR as of now. And I may be given liberty that as and when if I am named and accused, I can approach the court. This is what I'm asking. Let's place
This is
reliance
what
on
he's
this judgment.
submitting. This is his submission.
This has no bearing on the ED case at all.
So what is the purpose of the filing?
Yes.
If
It
that
stands
is
like-
submission, Lordship can close the matter as
Yeah.
is not maintainable.
So
This case is not
if
maintainable.
that is your submission, that is your prayer, what is the purpose of filing this?
Lordship, the purpose of filing this is if
So
today.
it automatically it is understood that if you are not named, if you are not involved, you will not be implicated.
I'll tell your Lordship my difficulty. My difficulty is
Then-
with the ECIR. Had there been no
It is
ECIR,
not connected
no,
here.
it is connected. Not in this writ petition, but those proceedings culminate out of the state of Nagaland Police's FIR. If there was no FIR of the state of Nagaland, there could not have been an ECIR against me. ED independently cannot register an ECIR. They have no power to register an ECIR or file a complaint. If
So how do we stop that then? How do
no,
we stop-
Lordship
how-
does not. I am not seeking a relief from your Lordship to stop the ECIR.
Mhm.
I am not asking your Lordship to do that. Whether that is permissible or whether that is not permissible, I will take my remedies available to me under law. What I am requesting to your Lordships today is that I have come for quashing of the state of Nagaland Police's FIR. The stand of the state of Nagaland is that relying on this judgment that I am not an accused, named accused in the FIR, thus I have no locus to challenge this FIR. If your Lordship deems it appropriate in terms of this judgment, dispose of this writ petition and grant me liberty that if and when or if I am made an accused in the FIR, I will have the liberty to challenge this FIR at that stage and I will be out of the court.
What benefit you get there?
I'll get a benefit.
Okay.
Then Lordship may take it. I'll take that benefit. I'll take that benefit.
Can it be? can
Whether
it be
any
done?
benefit is there or not, I'll let Lordship will leave.
Lordship can rely upon the judgment only to hold that the instant petition is not met. He cannot take a divergent route. He cannot take a divergent route. Good job. Good job.
You were reading out from somewhere. जो अभी सर ने बोली मेरे पास नहीं है जो सुप्रीम कोर्ट को ऑर्डर कर देता है
But then you say at this stage, we can't say, we cannot say that you are not involved, not found involved, because your name we have found here.
I am not asking your lordship to say that.
Hmm.
Lordship will see the second paragraph of this order
Hmm.
relied upon by my learned friend. It is not in dispute that the petitioners have not been named as accused in the said crime.
That is true.
If the petitioners have not been named as accused in the said crime, the question of quashing of stated FIR or the case now under investigation by CBI arising from the said crime does not arise, as the petitioners will have no locus to seek such a relief. In other words, the petitioner not being named as accused in the said crime or the case now registered by the CBI on the basis of said crime cannot be permitted to ask for quashing of the proceedings concerning some other person. I am not asking for some other person. So this paragraph is not relevant. Now lordship will see the last paragraph. Or let's read the next paragraph also. For the same reason, we do not intend to examine the correctness of the relief claimed under section 438 of the Criminal Procedure Code at the instance of the petitioners. It will be open to the petitioners to take recourse to appropriate remedy as and when they are named by the investigating agency in connection with the stated offence and now under investigation by CBI. This is exactly what I'm asking.
Now, what I'm saying is your name appeared here. Your name is appearing.
But my name is not appearing as an accused as of now. Lordship, there can be four possibilities. Either I am named as an accused, either I am named as a witness, either I am named as a victim.
Now probably since your name has been taken.
But still, in the FIR, I am not named.
FIR, of course.
So this judgment squarely that my learned friend applies now, factually is the same. I am only asking your lordship to say I am not an accused named in the FIR.
Can you dispose in that way then?
This is what the Supreme Court judgment says, relied upon by them.
Lordship has seen the investigation reveals he may not be an accused now. But when will he be an accused? He will be an accused when the charge sheet is filed.
Not necessarily. Not necessarily. You can make me an accused during the course of investigation. Also, suppose during the course of investigation, you require my custody. I will be an accused at that very moment.
Your custody will not come. You are sitting in Dubai.
You may require my custody, whether I may be, wherever I may be, or whatever remedy is available to me. And lordship will see that Supreme Court judgment, the following paragraphs. All contentions available to both sides are left open. It's their judgment, they are relying upon it. And I don't understand what is the opposition of passing the orders in terms of the judgment relied upon by them. From second paragraph till the next paragraph, the same order can be replicated in my petition. Lordship may dispose of this petition in terms of that and give me liberty. That if and when I am named as an accused, I will approach and take appropriate remedies in law. And this petition shall not come in the way of that.
Whether any notice was issued against you?
No, I haven't received any notice till
Not yet,
now.
not yet issued.
Nothing. So I am even on a better footing than this.
Okay, I'll pass order.
In terms of this, lordships will pass an order.
In terms of this.
Lordship may only take note, may grant me liberty to approach
Yes,
the
yes,
court again.
liberty will be granted.
And this petition should not come in the way of my approaching that too. That's the only request I'll make to you.
Take the name, huh? Mr.
Anindya Malhotra and Amit Singh.
Anina Malhotra and Amit Singh, counsel for the petitioner. I've also had Mr. Yangami, Lana PP in Nagaland, in the state of Nagaland. And Mr.
I'm R.K. Dev Chaudhary. from
Dev
TLC.
Chaudhary. Planet ASGI. Yep, for the respondent number 2 and 3. Okay. The time is also off. So I'll pass order, you'll get it.
Gosh. So nice.
You'll pass it.
Deeply grateful for a patient hearing, Lord.
Thank you.
I'm going back and I'm not coming for any indication in future. Huh? They have not paid me, huh?
Sir, you should have stayed away today. We are also behind. You are going to Gauhati. No flight to catch now.
You also got it all.
Tomorrow we'll take the early morning.
I think that's a late night flight.
Today there is no. Last time we took our 12 o'clock.
9 o'clock or so.
12 o'clock. Air India Express. 12 o'clock or 11 o'clock. Today I think that flight is not there. We'll take the Shatabdi now. So 5 o'clock. We'll reach at 10. Which is the airport near, what is this hotel near the airport, sir? Radisson, closest? The closest.
Food is lousy and
Which one, sir?
Radisson food is lousy and
By the time we reach, I don't think we'll be in a position to eat. It will be 10:30, 11. We'll have lousier food in the train.
I have to return to the service. My son is having some exam.
Okay. After you come in the car. In the rainy season also you like to drive?
No, I have not driven my own car. Sometimes I drive my car, but this time we given very noisy vehicle. It's very difficult. Yes, people are not against any hotel. No, yes,
You come in the morning or what?
no, I came yesterday. I stayed with the army. That much benefit I get.
Okay.
So, since
So this is unfortunate. They should provide at least their signing. At ASG level, they are doing this. ये आपका तो नहीं?
how this is done. And I have made it very clear to them, like, I'm not coming for